Before most Americans woke up, something rare and deeply consequential happened inside the U.S. power structure. Without warning, without public debate, without televised arguments or emergency addresses, in the middle of the night, the Supreme Court of the United States issued a 6-2-3 emergency ruling. That decision will begin affecting millions of people within weeks. This was not a routine procedural order. It did not quietly resolve a narrow dispute or correct a technical error from a lower court. What occurred overnight was a structural shift, one that rebalanced power between judges, presidents, and the public itself. While the country slept, the rules governing how constitutional rights are protected were rewritten across state capitals, federal agencies, and courtrooms nationwide. The legal landscape changed in hours, and almost no one noticed. There were no breaking news banners, no primetime panels, no urgent press conferences, just a short technical order written in legal language, carrying consequences large enough to destabilize a system that has protected constitutional rights for decades. That silence is not incidental. It is precisely what makes this moment dangerous. The most consequential legal changes in American history rarely arrive with fanfare. They do not appear in headlines. They do not demand attention. They arrive wrapped in procedure, in technical language, in the quiet hum of courts operating behind closed doors. At first, they feel abstract, academic, remote, but that is the illusion. Their impact becomes undeniable only when they collide with everyday life. When someone goes to cast a vote and finds the rules applied unevenly, when a family faces deportation, not because the law changed, but because the enforcement of that law suddenly shifted, when a regulation applies in one state but is suspended in another, when a constitutional right exists clearly on paper but is invisible in practice. This is how subtle legal shifts become seismic. The ruling that triggered this shift came from a case that looks narrow at first glance. Formerly titled Trump versus Casa Inc., it centers on an executive action tied to birthright citizenship. The subject alone is politically explosive, and yet focusing only on immigration misses the deeper story. The Supreme Court did not seize this case to settle immigration policy. It used it to resolve a decades-long quiet war over judicial power, a conflict that has shaped the structure of American governance for over 25 years. At the heart of the ruling is a legal mechanism few Americans have ever heard of, but one they have relied on for decades: the nationwide injunction. For roughly a quarter century, this judicial tool functioned as one of the most powerful checks on government authority. When a law or executive action was credibly challenged as unconstitutional, a single federal judge could block that policy from being enforced anywhere in the country, instantly, nationwide, while the case moved through the courts. One courtroom, one judge, one signature, and the federal government had to stop. Immigration enforcement froze, environmental rules stalled, healthcare mandates paused, workplace protections halted, gun laws deferred, voting procedures delayed, geography did not matter. A judge in California could halt a policy in Texas. A judge in Texas could freeze enforcement in New York. The injunction followed the federal government everywhere. It became a routine, unspoken foundation of modern American governance. Supporters argued it was necessary to prevent widespread harm while legal appeals crawled through the system. Critics warned it concentrated extraordinary power in the hands of individual judges, encouraged forum shopping, and allowed unelected officials to override national policy based on preliminary rulings. Yet both sides agreed on one point: nationwide injunctions were powerful. Until now, the Supreme Court's emergency ruling eliminated them. Trial judges can no longer issue universal relief. Courts can only protect the specific plaintiffs before them. No more countrywide pauses, no more nationwide shields. The implications are staggering. A law can now be ruled unconstitutional in one courtroom and still be enforced against millions elsewhere. Protections once assumed to be universal now exist only narrowly, contingent on who is in the case, where they are, and whether they have access to legal representation. The structure of power has shifted overnight. This is not an immigration ruling. It is not a narrow policy tweak. It is a fundamental redefinition of the American legal system, one that affects voting, health care, environmental regulations, and civil rights. One ruling, quiet and procedural, has rewritten the rules. And for millions of Americans, its effects will be felt immediately, sometimes in ways they cannot yet see. At the center of the ruling is a tool most Americans have never heard of, yet they have relied on it for decades: the nationwide injunction. For roughly 25 years, it was one of the most powerful checks on government authority. When a law or an executive action was credibly challenged as unconstitutional, a single federal judge could step in, one signature, one courtroom, and the policy stopped everywhere, not just in that district, not just for the immediate plaintiffs, everywhere. Immigration enforcement froze nationwide. Environmental regulations ground to a halt from coast to coast. Healthcare mandates paused. Workplace protections suspended. Gun laws and voting procedures deferred. Sometimes it took only a single lawsuit filed in a single district to halt the actions of an entire administration. Geography ceased to matter. A judge in California could stop a policy in Texas. A judge in Texas could block enforcement in New York. The injunction didn't follow the parties. It followed the federal government. It became a de facto national control. This authority reshaped modern governance. It transformed trial judges into referees with the power to stop national policies. It allowed courts to act quickly, preemptively, and decisively. Supporters argued it was necessary. Without it, unconstitutional policies could sweep across the country before courts had time to intervene. One preliminary ruling could protect millions of Americans while the legal system slowly worked its way to a final judgment. Critics warned of the opposite, that it gave extraordinary power to individual judges, encouraged form shopping, and allowed unelected officials to override national policy. Yet no one disputed its reach. Its power was real. Its effect was immediate, until now. In a single emergency ruling, the Supreme Court erased it. They did not limit it, they did not narrow it, they eliminated it. Trial courts may no longer issue universal relief, no more nationwide pauses, no more government-wide freezes. From this moment forward, courts can protect only the plaintiffs before them, only the people named in the lawsuit. If millions of others would also benefit from protection, they are out of luck. One signature no longer stops a nation. One judge no longer commands the federal government. The implications are profound. A law can now be deemed unconstitutional in one court, yet enforced against millions elsewhere. Policies once frozen nationwide can move forward unchecked in other states. Protections that Americans assumed were guaranteed may now exist only for a handful of plaintiffs. The balance of power has shifted overnight. The federal government can now act while lawsuits play out in individual districts. The strategic advantage has swung, and the landscape of rights, regulations, and enforcement has been transformed in a single, quiet decision. This was not just a legal ruling, it was a structural realignment, one that will ripple through immigration, healthcare, environmental policy, labor law, voting rights, and beyond. One emergency order, one ruling, and decades of judicial practice gone. The quiet power of the nationwide injunction has vanished, and with it, a foundation of American governance that had operated for a quarter century. The rules have changed, and the consequences are only beginning. The Supreme Court did not examine the executive order itself. It didn't rule on the policy, the politics, or the merits. Instead, it struck at the very mechanism that allowed courts to intervene. The majority declared that federal judges no longer have the authority to issue universal relief. From this point forward, courts may protect only the specific plaintiffs in the case. No more nationwide pauses, no more countrywide shields. That single, quiet sentence rewrites the rules of constitutional law in America. A law can be ruled unconstitutional in one courtroom and still be enforced against millions who were not part of the case. Protections once assumed to apply broadly across states, across borders, across the country, now exist only narrowly. For 25 years, the legal system operated under a simple, almost invisible assumption. If a federal action was likely unconstitutional, it could be stopped everywhere, immediately. That assumption is gone. The consequence is profound. Nationwide injunctions had turned trial-level judges into de facto national referees. One ruling, one courtroom, one judge, and the entire federal government had to halt. Policies stopped in their tracks, executives recalibrated, agencies froze, millions of lives and livelihoods paused, pending judicial review. It was extraordinary authority, but it became routine. Immigration enforcement, frozen nationwide, environmental regulations, halted coast to coast, healthcare mandates paused, workplace protections suspended, voting rules blocked instantly, no longer. Now the court has shifted the balance of power. The executive branch can push forward while challenges play out in district courts. One injunction here, one case there, but nothing that stops the country. The dynamic has flipped. Judges are no longer national referees. They are local arbiters. They resolve disputes for the plaintiffs sitting before them and nothing more. The implications ripple everywhere. A law deemed unconstitutional in California may still be enforced in Texas. A regulation blocked in New York could move forward in Florida. The predictability that once underpinned American governance, the idea that rights and rules applied evenly, has fractured. And this is only the beginning. 25 years of judicial practice evaporated overnight. Power, once distributed across courts to check government authority, now flows differently. Enforcement can continue despite ongoing legal challenges. Rights, protections, and legal remedies now depend on geography, timing, and access to the courts. The quiet majority opinion does not look dramatic at first, but its effects will be felt in every federal agency, every policy decision, and every American courtroom. This is not just a technical change, it is a structural transformation. The law has changed, the way it is enforced has changed, and the landscape of American rights, once predictable, once uniform, is now fragmented, uneven, and uncertain. For a generation, nationwide injunctions were the invisible guardrails of constitutional protection. Now those guardrails are gone, and the country will feel the consequences in ways that reach far beyond the courtroom. Supporters argued the injunctions were essential. They prevented mass harm while appeals crawled through the courts. Critics saw something darker. They warned that this power concentrated extraordinary authority in the hands of unelected judges. They cautioned against forum shopping, where advocacy groups hunted out sympathetic districts to stop policies nationwide. Yet despite their disagreements, both sides acknowledged one undeniable truth. Nationwide injunctions were among the most powerful tools in modern American law. They reshaped government policy with a single signature. One overnight order, one courtroom, one judge, and the federal government was halted. Then, in a moment few Americans saw coming, the Supreme Court acted. With one ruling, the court declared that tool illegitimate, gone. The message could not have been clearer. Trial judges are not national policy makers. Their role is not to rewrite laws or freeze them across the country. Their authority is to resolve disputes between the parties before them, not to act as a nationwide veto over federal law. The power to halt policy everywhere, the court concluded, was never properly granted. Decades of precedent vanished overnight. What was routine, powerful, and assumed suddenly became forbidden. The legal landscape shifted in hours. Rights that once carried nationwide shields would now exist only where they were individually litigated. For anyone relying on a single case to protect millions, the terrain had changed irreversibly. This was not a technical adjustment, it was a structural correction. The court sent a blunt signal. National influence does not reside in trial courts. Policy enforcement will continue even when questions of constitutionality remain unresolved, and the consequences immediate for civil rights groups, for states challenging federal authority, for ordinary citizens. The nationwide pause, the invisible safety net, was gone. The Supreme Court had redrawn the boundaries of judicial power, and in doing so, it remade the rules of American governance. What makes this moment historic is not just what was taken away, but how fast it happened. A power exercised for decades vanished instantly. No transition period, no gradual narrowing, one ruling, and the framework changed. And once that authority disappeared, the consequences became immediate. Without nationwide injunctions, the central question is no longer whether a law can be challenged. It is who will be protected while those challenges unfold. That is where the balance of power begins to tilt, and that is why this ruling marks the end of a legal era that defined modern constitutional enforcement. Once universal relief was removed, the redistribution of power became visible almost immediately. This ruling did not exist in isolation. It reshaped who can act, who must wait, and who bears the cost of delay. The clearest beneficiary is the executive branch. From now on, a president can continue enforcing contested policies even while those policies are actively being challenged in court, as long as enforcement avoids the specific plaintiffs in a given lawsuit. Legal challenges no longer freeze federal action nationwide. This is a fundamental change. Immigration enforcement, environmental regulations, labor rules, healthcare mandates, and election-related policies can now proceed across much of the country while litigation drags on for months or years. For administrations willing to push aggressive policies, this is a strategic advantage that did not exist before. State governments aligned with those policies benefit as well. States favoring stricter enforcement, looser regulation, or more restrictive voting rules are no longer vulnerable to being stopped nationwide by a single judge in a distant jurisdiction. A lawsuit filed in one district no longer paralyzes policy across all 50 states. On the other side of the equation, civil rights organizations suffer a major loss. For decades, nationwide injunctions were their most powerful weapon. One carefully constructed lawsuit could protect millions overnight. That leverage is gone. Now, instead of one case, organizations may need dozens. Instead of one order, they may face a patchwork of partial protections across jurisdictions. This shift is not just procedural, it is financial, it is logistical, and it is exclusionary. Major law firms already warn that constitutional litigation could become 5 to 8 times more expensive. Smaller advocacy groups may be priced out entirely. Individuals without institutional backing may find meaningful protection nearly impossible to obtain at scale. Power now flows toward those who can act first and endure uncertainty longest. Governments can enforce it immediately. Individuals must wait. Rights may eventually be recognized, but only after uneven enforcement has already reshaped lives, communities, and outcomes. The justices who supported the ruling did not view it as a power grab. They saw it as a correction. The conservative majority framed the decision as a restoration of constitutional limits. Federal judges, they argued, were never meant to function as nationwide gatekeepers. The Judiciary Act of 1789 authorizes courts to resolve disputes between parties, not to issue sweeping orders protecting people who are not before the court. In their view, nationwide injunctions inverted the judicial role. Trial courts became veto points for presidential and congressional action, often based on preliminary findings rather than final judgments. That, they argued, was not restraint. It was overreach. Concurring opinions reinforce this reasoning with historical analysis. Early American courts routinely refused to extend relief beyond actual plaintiffs. Judges resolved cases. They did not issue commands binding the government everywhere at once. Another critique focused on forum shopping. Advocacy groups learned to seek out sympathetic judges, knowing a single ruling could shut down policy nationwide. That dynamic, the majority argued, undermined democratic accountability and judicial legitimacy. From this perspective, the danger was not fragmented enforcement, but a judiciary that had quietly accumulated authority it was never meant to have. That belief explains the bluntness of the ruling. The court did not attempt to impose guardrails. It chose elimination. The dissent saw something very different. They warned that stripping courts of universal relief fractures constitutional protection itself. Nationwide injunctions, they argued, existed to prevent widespread harm while the legal system moved at its deliberate pace. Without them, unconstitutional policies can be enforced against millions simply because they are not named plaintiffs. Rights become conditional. One justice called the ruling an existential threat to the rule of law, a system where constitutional protections vary by geography and access to resources creates zones where the Constitution effectively does not operate. Within hours, theory became reality. Attorneys general from 18 states filed emergency motions. Some sought to preserve existing injunctions. Others moved to immediately enforce laws that had been frozen for years. Texas moved to narrow immigration protections. Florida targeted blocked election and tech regulations. California and New York rushed into court to salvage nationwide blocks. Behind the scenes, the federal government entered crisis mode. The Department of Justice convened emergency strategy sessions across dozens of active cases. Agencies were warned that dormant policies could take effect within weeks. This was not a transition, it was a scramble. And what became clear very quickly was this: your rights may no longer follow you across state lines. They may stop and start based on your zip code. The United States is now moving toward a system where federal law exists uniformly on paper, but operates unevenly in reality. Immigration enforcement, gun regulations, health care access, environmental protections, voting procedures, all subject to geographic fragmentation. Legal scholars warn this creates a rights lottery where protection depends less on the Constitution and more on timing, location, and resources. The economic consequences are already emerging. National companies once assumed federal rules applied uniformly. That predictability is gone. Now corporations may face different versions of the same federal regulation across states, raising costs, increasing risk, and slowing investment. Compliance becomes regional, planning becomes unstable, volatility rises, and all of this was imposed not through extended debate, but through the shadow docket. An emergency mechanism once reserved for narrow disputes is now reshaping foundational law. One late-night order dismantled a system that defined constitutional enforcement for decades. No hearings, no oral arguments, minimal explanation. By the time consequences become visible, the shift is already locked in. This ruling did not just change procedure, it changed the meaning of protection in America. Rights still exist, but their enforcement is no longer automatic. They must be pursued, they must be litigated, and often they must be fought for again and again. And that is why this moment matters, because the most consequential shifts in power do not always arrive with speeches or sirens. Sometimes they arrive quietly in the middle of the night, rewriting the rules while the country sleeps.